I'm Bob Hauser, Executive Officer of the American Philosophical Society, held at Philadelphia for promoting useful knowledge. And I have the pleasure of introducing two people who are far more distinguished than me, sort of directly and indirectly. And the first is Clyde Barker, distinguished transplant surgeon, author, and former president of the American Philosophical Society, who is going to introduce the next exceptionally distinguished person, our keynote speaker for the evening, Secretary Donna Shalala, and formerly my boss at the University of Wisconsin-Madison, but we won't go into that here. Anyway, here's Clyde Barker. Thank you.
It's my honor to introduce Donna Shalala. She was born in Cleveland and earned her bachelor's degree from Western College for Women in Ohio. After that, she served for 2 years as one of the country's first Peace Corps volunteers in a rural farming village in Iran, helping to construct an agricultural college. She then earned a PhD from the Maxwell School of Citizenship and Public Affairs at Syracuse University. In 1972, she became professor of politics and education at Teachers College, Columbia University. During the Carter administration, she kept busy serving as Assistant Secretary for Policy Development and Research at the U.S. Department of Housing and Urban Development. From 1980 to 1988, she was president of Hunter College. And then for the next 8 years, she was chancellor at the University of Wisconsin as the first woman to lead a Big Ten conference school. Well, there, in addition to doing a number of things to increase the prestige of that university as well as its endowment, she hired football coach Barry Alvarez, the record holder for the school's football wins with 4 appearances in the Rose Bowl. She then served for 8 years under President Bill Clinton as United States Secretary of Health and Human Services, becoming the nation's longest-serving HHS secretary. From 2001 to 2015, she was president of the University of Miami, and after that was elected to a term in the U.S. House of Representatives. President George W. Bush selected her as a recipient of the Presidential Medal of Freedom, the nation's highest civilian award. She's also a recipient of the Nelson Mandela Award for Health and Human Rights. In 2019, she became one of the members of the inaugural class of the Government Hall of Fame. We look forward this afternoon to Secretary Shalala's keynote address on crime and punishment in American medicine.
Thank you, Dr. Barker. It's a great honor to be introduced by such a distinguished physician and physician leader. I'm happy to be here. I want to thank the College of Physicians and the American Philosophical Society, which I'm a member of. And I know that reference to football at the University of Wisconsin came from Bob Hauser, my good friend and former colleague. I didn't know anything about football before I went to Wisconsin. I appreciate the step up. I was actually 3 inches taller before I went to Washington the first time. The criminalization of medicine has a long and a very complicated history. It's an issue that requires very careful consideration of the balance between individual rights, public safety, and medical ethics. we know that different societies and different cultures treat medical practice in different ways. Throughout history, there are numerous examples, some of which are not on the tip of your tongues. But we want medical professionals to be held accountable for their actions when they intentionally harm patients. However, it's also important to recognize medical autonomy and the role of medical professionals in providing compassionate and effective care. The criminalization of certain drugs, such as marijuana, legal in parts of the country but illegal federally, causes very complex issues. End-of-life care has also had its challenges, and that's a separate story. Our concern must be that the criminalization of medicine can have significant implications for public health in this country. It can discourage patients from seeking treatment. It can discourage doctors from providing certain types of care. It also has significant ethical considerations. While the battle on abortion goes on, gender-affirming care may be the next battlefield. And Florida, my home state, is a very concerning example. It marks the first time a state has used medical boards, which typically license and discipline physicians, with oversight by the Florida Department of Health, to restrict care for transgender patients. Alabama and Texas lawmakers are making it a criminal offense. And by the end of last year, 15 states were considering similar legislation. In Miami, a clinic serving trans youth at the Nicholas Children's Hospital has shut down. A spokesperson confirmed, and a similar clinic at Johns Hopkins All Children's Hospital in St. Petersburg has paused operations indefinitely. Another clinic at the University of Florida, Gainesville, has a wait list. It takes between 3 and 6 months to get an appointment. On Saturday, a University of South Florida adolescent pediatrician wrote on Twitter that doctors were recently told by the institution's legal department that we have no choice but to comply with the new rule. It's unconscionable that I fear may lead to so much preventable harm, one of the doctors said. There are other recent examples of criminalization of health care. A Tennessee nurse whose medication error resulted in a criminal prosecution. Most of us have seen the effects of the health profession and institutions make significant efforts in patient safety since the publication of the IOM, now the National Academy of Medicine's report, To Err is Human, in 1999. That report asserted that the problem is not bad people in healthcare. It is that good people are working in bad systems that need to be made safer. The legality of abortion has always been precarious. And now with Dobbs, we can expect punishment in a new era of criminal abortion that will echo the policing and the prosecution of the past, but is likely to be made even worse because of the many post-Roe state laws that name the fetus as a person and make pregnancy loss and abortion into crimes of manslaughter or murder. For providers of women's reproductive health, it is a scary time for the medical profession and for their patients. In the 17th and 18th century and the beginning of the 19th century, abortion was common practice. However, as Leslie Reagan explains in her path-breaking book, When Abortion Was a Crime, how 19th century organized medicine pushed to make abortion a crime and give doctors the power to monitor women's bodies, their behavior, and their adherence to gender and sexual norms. Physicians actually became part of law enforcement during that period and testified in court cases brought against abortion providers. However, the medical profession also felt competing pressures as well, and many providers during that period provided illegal abortions. The criminalization of abortion in the 19th century was, according to Professor Regan, rooted in the anxieties of upper-class white men who resented women's political activities and who feared losing political, economic, and cultural power to people of color. Of course, they were talking about African Americans and Native Americans and Chinese migrants and the European Catholic migrants. None of the new laws stopped abortion. From 1960 to 1973, abortion was a crime. That enforcement was changed over time, and during the Depression, state authorities curtailed enforcement, and law enforcement shifted with changes to the economy, the organization of medicine, and the political climate at the time. By the 1950s, a two-tiered system of illegal abortions existed, defined by race and class. As a graduate student, just before Roe, I witnessed personally the danger of illegal abortions by friends and students. I had friends who went to Chicago, to Puerto Rico, to El Paso, to cross over to Juarez to get safe abortions. And one night, actually it was the afternoon, unusually, I returned to a dormitory where I was the resident advisor and found a student bleeding outside of my door. She said one word to me, abortion. She was almost unconscious. It was a nightmare to get her to an emergency room and to find a physician that would treat her. The emergency doctors weren't even willing to stabilize her. They were so fearful of the laws. But I had gone to a NOW meeting as a graduate student. They actually wouldn't let us in. They let us stand in the back because we didn't have the money to pay the dues. But I had listened to an OBGYN talk about abortion and talk about women's reproductive rights. And I think it may have been the first time I ever heard the term. And he had explained a lot of things. And I remembered his name, and I asked the hospital to track him down. And he came over and saved that young woman's life. It was a searing experience for me, and I never forgot it. The criminalization of essential health care includes the full range of sexual and reproductive health care, such as abortion, both medical abortion, surgical abortion, contraceptive care, and it is dangerous and unethical for us not to provide these kinds of services. Government interference in the practice of medicine, as indicated in the history of abortion, is not new, as I've indicated. The medical professional organizations have been firm, though, in this country, in their view that Dobbs, along with subsequent actions at the state level, represent an assault on reproductive health and safe medical practice. In 2022, the AMA said very clearly, patients and physicians need assurances that they won't be accused of crimes for medically necessary treatment. Unfortunately, this is the post-Dobbs world we now face. The fact that medically necessary treatment can be criminalized speaks volumes about these misguided abortion laws. End of quote. State laws that interfere with medical practice in this area are sometimes vague, restrictive, complex, and conflicting, which leads healthcare institution lawyers to close down access. Recent efforts by states to ban the sale of the drugs for medical abortion are even more confusing. None of the current state abortion bans or restrictions criminalize the pregnant women for obtaining self-managed abortions, but there are some cases of criminal charges. Some states impose criminal penalties on clinicians or others that help an individual obtain abortion services. This is a scary time. These policies create a climate of fear related to self-managed abortions, as well as both for patients and physicians. For example, if a patient is to present to a clinician for a complication or follow-up care after a self-managed abortion. We have talked a lot in the previous panels, mostly about surgical abortion, but I'd like to say some words about the introduction of the pills. First, of what we called RU-486, which is mifepristone, and later the second pill, which induces abortion without surgery and now accounts for over half of the abortions in the United States. This is the new world of abortion. There is, of course, a dangerous federal case in Texas challenging mifepristone. While the statute of limitations has run out in that case, the plaintiffs have not exhausted their administrative remedies and have not identified a provision of the law that has been violated. It's one of the safest drugs on the market, and its history is interesting. It was a phone call that my department, the Department of Health and Human Services, received in 1994 from a representative of the French drug company, Roussel Uclef, offering to give the Department of Health and Human Services the U.S. patent rights free for RU-486, for mifepristone, the medical abortion drug, for free. The drug, which had been approved in Europe, in France in particular, was already widely used by thousands of women. However, it was not available in the United States, and in fact, President Clinton, when he signed his first executive order, had asked the department to try to find a way to bring it to the United States. But it was a phone call offering it free, the license free to the department. I was suspicious. In 1990, leading scientists had testified before Congress that the FDA ban that hindered research on the medical benefits of that drug, including treatments for some cancers, HIV, uterine tumors, and for inducing labor. But by the fall, the Institute of Medicine suggested that a new drug application be submitted to the FDA for the use of the drug, a two-pill procedure as a method of early abortion. Back to the phone call. Patent rights to the government for free. All I could think of is this would create an unending politics for the United States government. The idea, and I knew of no precedent for the United States government accepting a patent from a private drug company. And so, while everybody in the department was very excited, I slowed them down. And I asked them to go back with to the representatives of Roussel Uclef and see if they insisted that we take the rights for free. I wanted to understand something about the politics. They kept insisting that it begin to the United States government. Now, why did they want to get rid of it and give it to the United States government? It turned out that they had introduced it in France and received a lot of pushback from anti-abortion groups in France. So they pulled it off the market, and then the French government demanded that they put it back on the market. So the last thing they wanted to do was to get deeply involved in U.S. politics. But I still was unclear about why a significant drug company would give away their patent rights. So I called the only person I knew that understood French business politics, Felix Rohatyn, the chairman of the great French banking firm Lazare Frères. I had actually worked with Felix in 1975 during the New York City fiscal crisis. He headed a government organization which I was a member of called Big Mac. I was a kid. I was in my 20s, just out of Syracuse, but I knew something about the financial relationship between cities and states. They put me on this board, and I got to work with Felix. And I knew Felix could explain to me what the problem was. It was quite simple. The CEO of the company was very Catholic and a friend of the Cardinal of Paris. And he simply wanted to get the drug. He did not want to introduce the drug in the United States, and he simply wanted it, the politics to go away. And as I indicated, they had the French experience. It took some time, but by 1994, actually May 16th, after a lot of maneuvering, we convinced the French company to give the license to the Population Council. That kept it out of the government, out of the Congress's purview, and it was up to the Population Council, who had a number of donors, including Warren Buffett and George Soros, and a number of major donors who were pro-choice and were willing to help finance the clinical trials. So the Population Council was responsible. At a hearing in 1994, before the Senate Finance Committee, we explained that the Population Council would take care of it and would do the clinical trials. And David Kessler, the FDA commissioner at the time, assured Congress that the drug would be subject to the same standards of proof of safety and effectiveness that apply to all drug applications. There would be no shortcuts. This is important in terms of the case that's now in Texas, because that case is exactly questioning whether the FDA took some shortcuts to approve the drug. My job was quite simple: to insulate the FDA, a regulatory agency, from any kind of political pressure, from any requests for information from the White House or from Congress. I did not make a lot of friends in that process, but in fact, it took years to get the clinical trials straight, to get the FDA approval, but it was in fact approved with another FDA commissioner, Jane Haney, who had been dean of the medical school at, I think, Kansas, and at New Mexico as well. And she was the FDA commissioner, and in 2000, she informed me a few minutes after the FDA had released the press release announcing it had approved the drug. I, of course, then informed the president. CNN actually had the news out before my call to the White House. Needless to say, I pissed off a lot of people at the White House in the process. But we will be able to testify in that court case or any other court case that there was no politics involved in the approval of the drug. That's the story about a pill combination that may make the difference as we wend our way through this terrible politics and terrible criminalization, which is a violation of human rights whenever government intrudes into medicine and impedes access to the safe and evidence-based reproductive health services, including abortion and contraceptive. Government systems of control and punishment that criminalize reproductive health service is dangerous to the patient and puts healthcare professionals in an ethical dilemma. This is all about patient safety. The last point I want to make is about last September. An ethicist, the former head of medical ethics at the AMA, Matthew Weine, wrote an article, an editorial actually, in the New England Journal of Medicine. He asked this question: what should medical professionals do when a law requires them to harm a patient? That's the central question. That's the central question. We are criminalizing, creating criminal law that medical professionals must follow, which will harm their patients. He urged something very interesting, a thoughtful debate over whether and how to embark on a path of professional disobedience. Not something we've talked about in American medicine, professional disobedience. And he gives a series of examples of how physicians all over the country could inform and pressure politicians in their states. The least we can do is protect the backs of the doctors who provide high-quality reproductive care. I actually believe that there's a long history related to tort reform, to medical malpractice, that forces physicians into a behavior that they wouldn't want to do ordinarily, to protect themselves and to protect their patients. In this case, we've criminalized a lot of this. So based on his editorial, and at the recent annual meeting of the AMA, they passed a resolution committing the AMA to support physicians who are pursued by state prosecutors when they're providing high-quality standard of care in reproductive health. The last I heard, the AMA was saying that it will pay the legal fees of physicians that were hounded, demonstrating for the AMA great courage and leadership. Clearly, it is the vagueness of these laws, many with exceptions, that have provided reticence on behalf of physicians and other healthcare providers, sometimes with lawyers for institutions interpreting the law more strictly than the law requires. I've had extensive experience with this myself, running large health systems, where the lawyers want to tighten up because they're protecting the institution, and I want the physicians to be able to practice according to the standard of care in their own judgment. When it comes to treating pregnant patients who are facing life-threatening conditions, this is where the vagueness has created unbelievable problems. As soon as the patients are seen, well, before the situation is actually mortal, yet anecdotally, we are hearing that some physicians are hesitating to act quickly. We cannot have this. And that's why all of us must be brave. We must ask the medical profession, we must ask our friends and neighbors to understand that physicians do have the discretion, that we want them to use it, to use their best judgment. And we want to protect them. Some laws will protect them, some federal laws. When we wrote the privacy laws, the famous HIPAA, I hesitate before a medical crowd to say I had any role in writing HIPAA. When we wrote HIPAA, we actually anticipated problems with abortion. And so part of the section of HIPAA was to protect physicians and healthcare institutions from having to reveal patients' private information. And the principle of HIPAA was simple. Healthcare information should only be used for healthcare purposes. Our concern was access from law enforcement. And so we actually wrote a section in HIPAA, which I referred to in a question in the other panel, that required that law enforcement, if they wanted individual patient data, information, that they had to go to a court or have a warrant issued or some other kind of legal document and explain why they needed that information. We were thinking about abortion when we wrote that section. That section was the only section of HIPAA that the Attorney General of the United States objected to. Very interesting. A very progressive Attorney General in the Clinton administration who had been a prosecutor. And her objection was that she thought law enforcement should have a direct access to patient information. My Inspector General felt the opposite. She felt that she couldn't have a credible relationship with individual physicians, with healthcare providers, with healthcare institutions when she wanted to pursue fraud if they didn't have some protection. Particularly, she felt strongly that she should have to go to a judge or to administrative judge and get some kind of piece of paper explaining why she needed the information. When two cabinet officers object to each other, you don't go to the Supreme Court. The Supreme Court is the chief of staff for the President of the United States. And so with the great General Counsel of the Department, Harriet Rabb, who herself was deeply committed on reproductive rights and who had worked on these issues at Columbia Law School, I went off to face down the Justice Department with, in front of the then Chief of Staff, Rahm Emanuel. Now, if Janet Rito in the Justice Department was law and order, Rahm Emanuel was even worse. And he sided with them. But we decided that we couldn't let this one go. So I had the option of going directly to the president or waiting. And as I said to someone the other day, I've learned a lot from football. The great running backs at the University of Wisconsin were very patient. They waited until the hole opened up and then they ran through it. So I waited until Rahm Emanuel left and John Podesta came in. And John Podesta turned to the Justice Department representatives and said, "Are you out of your mind to let some sheriff go into a doctor's office and rifle through and find out what women in the community had had abortions?" And so we won that battle and sent the privacy regs to OMB for approval. They were approved in 2000, actually, fairly quickly. We were working on them at the same time that FDA was working on the drugs. Maybe those two things will make a difference. I'm proud that I had an opportunity to lead the department that at least introduced them, that took a position on criminalization of abortion, but all of us have a big job to do. Thank you very much.
Thank you so much, Madam Secretary. That was just wonderful. And of course, as hearing from you as ever, I've learned a lot, and I expect everybody else has too. So I'm going to take a minute at the podium here. Gosh, I'm tall. Thank you, Donna, for that too. To introduce our three panel members here. Anita LaFrance Allen is the Henry R. Silverman Professor of Law and Professor of Philosophy at the University of Pennsylvania Law School. She was formerly Vice Provost for Faculty from 2013 to 2020. She's been a Senior Fellow in the former Bioethics Department of the University of Pennsylvania Perelman School of Medicine, a collaborating faculty member in Africana Studies, and an affiliated faculty member in the Gender, Sexuality, and Women's Studies programs. She's been elected to the American Philosophical Society, the National Academy of Medicine, the American Law Institute, and the American Academy of Arts and Sciences. In 2010, President Barack Obama named Allen to the Presidential Commission for the study of bioethical issues. Chris Feudtner, an MD and PhD, is a pediatrician, clinical investigator, and ethicist at the Children's Hospital of Philadelphia and the University of Pennsylvania, who focuses on improving the lives of children with complex chronic conditions and their families. Over the years, he's conducted a wide variety of research projects and been involved in developing clinical programs while also taking care of complex pediatric patients, including providing palliative care, as well as clinical ethics consultations. He's received numerous awards for teaching, mentoring, and research, having published more than 180 articles and book chapters. Among his many research efforts, Dr. Feudtner helped establish the Pediatric Palliative Care Research Network, a network of leading researchers in the U.S. and Canada who work collectively on improving pediatric palliative care services. And some of us have already heard from our third panelist, Julia Haller. She's an American ophthalmologist who's professor and chair of the Department of Ophthalmology at Sidney Kimmel Medical College at Jefferson University. She also holds the William Tasman MD Endowed Chair at Wills Eye Hospital in Philadelphia, where she is Ophthalmologist-in-Chief. She's a member of the National Academy of Medicine, numerous international scientific advisory boards, and sits on the Board of Trustees of the Association of University Professors of Ophthalmology, the College of Physicians of Philadelphia, and the Society of Heat Fellows. She's a former president of the Women in Medicine Legacy Foundation. She also serves on the board of the Johns Hopkins Medical and Surgical Association and the Philadelphia Orchestra, and is a past member of the Board of Trustees of Princeton University. So with that, I am going to ask Julia to start. We'll work this way and give you a few minutes to say whatever you would like to say in response to or reaction to or thoughts about what Donna has just told us, and then we'll have a little general discussion amongst the panel members, and then open to Q&A from everybody else here. So.
Well, thank you so much. With the people behind me on the wall, I couldn't help but think of the lines from the play Hamilton, where they have the song "The Room Where It Happened," because I really felt like that talk gave me some insight into the room where it happened. And I think for those of us who've lived through HIPAA and the introduction of, I really remember things playing out that you were talking about, Secretary Shalala. And, I'm so grateful for your work on behalf of all of us. I was fascinated to hear about the backstory of the FDA process, because that was so much central to what we were discussing in the legal section just a little bit ago. And it gives me confidence that when I see you up there testifying in Texas, that that won't hold. I mean, revoking an FDA approval, something that would be unprecedented. So. Anyway, I was fascinated by the talk. I think you raised wonderful issues, and it was a fitting keynote for our afternoon discussion. I look forward to everybody's questions as well.
Thank you. I also really enjoyed that inside baseball account of HIPAA and some of the other fascinating stories, RU-486, that whole story. Back in the 1990s, I was the chair of the board of Planned Parenthood of Metropolitan Washington that operated 6 clinics in the DC, Virginia, and Maryland area, and we were very concerned about and excited about, in some ways, about what would happen with RU-486. And I was, at that time, unable to believe that the day would come when it was the main way women obtained abortions. But as you point out in your talk, it is the abortion pill approach is now the most common and popular approach.
I testified that we didn't think it was ever going to be the main answer, that we thought maybe it would be 10%, but that it would not be the central piece that we have now.
Yes, it's fascinating. We can talk about why it got popular in a few minutes, I hope. You raised the case Alliance for Hippocratic Medicine versus US FDA in your talk, and this is the most terrifying case I have. It's as terrifying as Dobbs for what it stands for. It's an attack on the very authority of the FDA, and hence on the ability of Congress and its regulatory agencies to do their job, right? It's a very, very serious attack. And if it works, oh my goodness, even if the judge just simply issues a preliminary ruling that temporarily halts the availability of the drug, it's a catastrophe.
It's very interesting. We wrote HIPAA because Congress couldn't. They actually wrote a law that said if they couldn't get HIPAA done, that the Secretary of HHS had to do it. So in 1999, my staff came in and said, guess what? we got to write the privacy rules. And I thought, oh my, one more thing. But it was because Congress ordered us to do it.
But I'm glad that Congress ordered you to do it. Right. And I'm going to give the mic away, but I hope we can also talk more broadly about some of the reasons why maybe doctors should go to jail sometimes. I mean, seriously, right? If doctors are sterilizing poor black women or poor Hispanic women or women with mental disabilities against their will without informed consent, maybe they should go to jail. If doctors are abusing gymnasts, right, maybe they should go to jail. If doctors are sexually abusing their OBGYN patients, as a doctor in Johns Hopkins did a few years ago, they should go to jail. And so there is dangerous, criminal, unethical, immoral, horrible conduct that some doctors, not the ones in this room, but some doctors engage in, and I think criminal penalties are appropriate. But it's not appropriate to put a doctor in jail for prescribing birth control or providing an abortion.
Or necessarily making an honest mistake or a mistake, because we've gone through that with to err is human.
So I'm sitting up here, never feeling as small as I do right now, sitting between.
Well, you're a pediatrician, you work with small.
I work with very small patients. So as a palliative care doctor, I often am trying to tune into the latent part of the talk, but you made it very explicit, the criminalization that is going on in the politics of what is going on. And in fact, I would pivot and say this is really about the politicization of medical care, with criminalization being one tool that is being used, but it is a broader phenomenon, one that is not shared culturally by the vast majority of Americans. It is a political minority that has power that is largely promulgating the laws that are going on. As an ethicist, I feel that we could talk about principles, and we need to stay focused on what's really at action here, which is the politics of growing intolerance to views that people do not want to be able to let people have liberty to have. It was Jefferson who put in front of the Virginia state legislature early in the days the first act of trying to legislate religious toleration. It eventually got picked up by Madison and got put into the Constitution. So it is very fitting we're sitting in front of him. Because the question that I keep coming back to is how do we unwind this politics of everything? It's been said that when everything becomes politics, you can't make any progress because you stop having the ability to have dialogue. What we really want in medical care is to be able to talk with the patient, use medical knowledge and customize care to best of our knowledge to be able to achieve the goals that the patient, the family want. We do have some interesting counterexamples, and I hope we can touch on them, where we are moving politically in a different direction, where we're decriminalizing medical aid in dying, something that would have been anathema. It was anathema and was illegal. And increasingly, that is being eroded. So I do think that there are ways for us to be more clever in thinking about how we mount the depoliticization of some of these problems, but they are political solutions to the challenge that we're currently facing, not just philosophical or ethical.
End-of-life care is an interesting, your point about end-of-life care, because there the laws and the ethics have aligned, and it really is a matter, and it took a long time into the 90s and later to bring the two together because doctors weren't sure that they wanted to do that. And we still have problems with physicians feeling comfortable.
And we're making progress. And
Yeah.
I think it is a multi-front campaign of both public education, the Conversation Project, stuff Atul Gawande has written that has helped many people start to think about this, efforts in all sorts of communities, at the church level even, to think about advanced directives and conversations that you need to have with your loved ones about how you want to be cared if you're really ill, as well as changes in the medical system to enable that to move forward. So I think that it is always important to be thinking at multiple levels when you're dealing with a cultural problem that is also being manifest as a medical problem.
Dr. Helen?
I wanted to ask you all, as ethicists and legal experts and political experts, what did you think about the social disobedience points that were raised earlier in terms of physicians pushing back in that way?
You know, it's an interesting article. Everybody should read it in the Journal of Medicine because it actually has a whole discussion about organizing physicians for civil disobedience. It's the first time I've ever read anything like that. But it obviously influenced the AMA in the statements that they put out and gave them some backbone.
I know. It makes me feel like Martin Luther King or, Gandhi or...
Well, I mean, that's exactly right. I mean, it's kind of a civil rights issue, right? The ability to have access to safe and effective medical care, it's something which could be characterized as a civil right, and the people, doctors and nurses and others who get on the front lines out there and disobey could be seen as similar to King. I mean, the thing about King, though, is he was willing to go to jail, and I don't know that there are very many people who are that saintly, who are willing to go to jail for their principles. But I'm reminded of the famous Supreme Court case, Griswold versus Connecticut, way back in 1964. It's the case that got us the right to birth control. Well, what had happened is that the medical director of Planned Parenthood in Connecticut deliberately got herself arrested so that a point could be pushed. Actually, two medical professionals at Planned Parenthood in Connecticut got themselves arrested because they wanted to have a test case go to the Supreme Court. And so for them, fortunately, the punishment for which the crime for which they were convicted, the punishment was only a small fine. It wasn't, going to jail for 10 years. But I do think that we do have some precedent in this country for people in the medical profession being on the front lines of pushing against unjust laws. And I do think this is the moment when some degree of pushing is going to be important. And not that, again, I want to see people who could be doing better work in the hospital, or in the clinic, going to jail and rotting in jail, but I do think that some degree of bravery and recognition of civil rights is an important part of all this conversation.
Safety, I think people often have a mental model, is the reduction of risk. I prefer to think of it as taking prudent risk, of selecting what risks you are willing to take for a particular purpose or goal. And I think that applies often in some of the more complicated patients I take care of, and also applies here. And that is often the dialogue we have with our general counsel about the risks that we are willing to take, even as an organization, because there's no way to play this game risk-free and win.
Well, particularly the kind of decisions that surround someone who has complications, we don't want doctors to hesitate. And we want, because we can defend a standard of care.
And I'm lucky to work at a place where that is the attitude, but it does require thinking about the risk of that hesitation on what it does, not just for that patient, but for future patients and the way that you think about the mission that you are trying to accomplish.
I will say something about risk-taking in connection with this event, and that is that hospital lawyers are very reluctant to speak publicly about these issues, and we had, I think it's fair to say, Mira can correct me if she wants to, that we had no great problem filling the medical and ethical panels that appeared earlier today, but it was a bit of a struggle to find two people who were in the legal part of the business who were willing to speak in public about these issues. A couple of deans, yes, a couple of deans. Maybe they felt a little removed.
But part of it is that it would be unethical for a lawyer to speak against the interests of their clients. and that's a problem. So you can't just say, oh, come and give us your opinion, because if their opinion does not coincide with their representation, it could be an ethical problem for them.
So let me ask one,
Representing the institution.
Yes.
Yeah, and that was one of the more disturbing things that we heard, that is that so many lawyers around the country would err on the side of letting the patients go down the hill and have the malpractice claim rather than risking going against the law.
right.
Not just the lawyers. I mean, one of the things I want to point out is that doctors themselves, because of malpractice, have changed their practice. That depending on what state you live in and what the torts
Right.
situation is.
Right, but we also are lectured to by the insurance companies who make us do step edits.
absolutely.
And, there's a certain infantilization of the medical practice in some ways. There's so many restrictions and regulations. And I think this is an egregious example of where we have to fight back.
So let me ask my one question of the panel, and then open it up for everybody. And that is, most of the conversation here has been about pushing back against Dobbs, and as Dr. Feudtner has put it, this is really about politicization and not just criminalization. And so my question is Dobbs really the end of it? Secretary Shalala referred to the business of transgender care, and I recall some stuff in the press following the Dobbs decisions about the interest of one of our Supreme Court justices and rolling back access to contraception. So is this the end, or is this just the beginning?
Well, we also heard in our first talk today about the politicization of gun control and the emphasis on gun safety, steering the conversation to safety rather than control to try to get away from the politics of it.
Right. We had the sort of hole in the enterprise earlier today was
The continuation. I think we've got lots of examples. Disability, disabled people, I mean, there's a whole history here.
Yep.
It's not going to stop. If to answer your question
with
bluntly.
with that. I think we'll give Annie the mic, or a mic, or do you have a mic? Oh, you have a mic. So let's open it up to everybody else here.
And we might want to think about why it's not going to stop. And in part, it's because the political problem that the politicization is trying to solve, which is electability and our politics right now, is fueling the continuation of this. And that's what I am curious is, how do we reverse that cycle? Because right now we have created a marketplace for this type of conflict paying off. And part of what I think we need to think about in civil society is, how do we peel that back?
It's also anti-science. That the context for all of this is anti-intellectualism, anti-science, what we saw during COVID, not trusting public health. So it's layers that are reinforcing the politics, Chris.
Right, and we've seen historically undulations in that anti-intellectualization.
Well,
And
since
then-
Jefferson.
Right, and they can reverse.
Okay. Anna Meadows.
I think we talk about not being political, but I think it's definitely political. Think about it. There are most of the people in our country, by various polls, agree that abortion should be legal. Most people agree that we have bad gun laws and we need to get rid of assault weapons. Most people would agree that parents should take care of their transgender children the way they feel they should. So why don't we all get out and get the vote? Get people to vote, because that's where the change is going to happen. So it is political.
I teach this huge undergraduate class, and every year I ask them, I tell them, what is the one thing they would do to improve the healthcare system? The only kid that got an A+ said campaign finance reform.
Other questions?
I thought it was a good answer.
Great answer.
In my former political organizing days, I was always told, don't bother to call back the doctors. They're all Republicans, and they're cheapskates. They don't contribute, and they don't vote our way. So I'm just sort of wondering, how do we get the medical profession a little more involved on the voting and the politics, because they're under attack right now. And I'm just curious whether that's changed, whether I'm just over the hill on that, or what the statistics are on the medical profession and their willingness to contribute money and vote and educate the public.
Do we actually know the data on the politics of the political parties? Say that most of the physicians and other healthcare.
No, we don't know.
We don't really know. I mean, we have impressions, right? Yeah.
Yeah.
Oh, okay.
University of Michigan knows, survey research there.
They have concluded that there's a strong conservative. Of course, it may be that some of the doctors don't think that they should be sort of one-issue voters, right? That their larger interests are with more conservative politicians, even if they don't agree about how the abortion issue plays out.
Who are the conservative politicians anymore? This is not a conservative position. Conservatism is not doing rebellious, invasive acts. So I think part of what is changing is that the easy ways to categorize the way that the political landscape lays are changing. So I think that there are options to think about political mobilization of physicians, even if they register under different party lines, that they may see very similar common cause in certain lines of protecting a lot of what we're talking about today.
Yeah, and you're probably right. I mean, if you ask Texas doctors whether they think that a random judge should be trying to bring down the FDA, I think they'd probably say no. That's going too far. That's like legal terrorism. It's not conservatism.
We can't simply be searching for people that are pro-choice. This is not about pro-choice. This is about the healthcare system's ability to practice and to
Professional
that's the common
autonomy
cause.
and also the doctor-patient relationship. And I think for many of
Doesn't have
us, that's
anything to do
the
with your
key
ideology.
piece that people think they can get in the way of the
The
physician-patient
doctor-patient relationship.
Yes,
Yeah.
the critical thing.
Are probably more anti-government than they are. I mean, the coalition has to be broad.
Okay. There are people
Way up there, yes. We don't have anybody up there with a mic, so you'll have to shout.
Sorry.
We'll repeat the question.
Okay. Secretary Shalala, thank you so much. I was in residency when HIPAA came out, so I really appreciate learning about this behind the scenes. I was thinking about your point, sir, about depoliticization. I recently registered in locums, and I specifically said I did not want to go to certain states that had issues like this because it's scary. But then it occurred to me when you were speaking that by not going to those states, you're also depoliticizing it, and patients get hurt, and then they're going to get angry enough to maybe affect change. And specifically, I was thinking about, I think it's Iowa, where they don't have enough GYN docs, maybe anesthesiologists who are willing to do GYN care. And they have to travel at great distances. So it's almost going to get depoliticized in a weird way, but it's, that's it.
Yeah, I think it's a good statement. Yeah, go ahead. Someone want to respond to that?
Well, if we could get the patients behind us, I think that, that's a good coalition. I mean, I think it must be terrifying to be there, especially as a young person or a person of color.
What was the question?
It was about physicians not wanting to go to these places and work, and then what's going to happen to the patients there, and are they going to rise up and say, we need some physicians and we need to change the law? That's how I took
Look,
it.
gynecologists are already scarce. Hospitals are closing, are not delivering babies. not just about abortion. It's about malpractice insurance and how expensive it is, and institutions, health institutions, clinics, hospitals closing down those services. That compounds this. And that's why I think we have to look at it within a broader context.
But I don't think it's realistic to think that the population of some of these states is going to rise up, right? Because take Mississippi, where there are now, I believe, no abortion providers because of Dobbs, who are impacted. It's going to be mostly the poorer women in a very, very poor and a very, very poorly educated state. The women who are educated and affluent can go out of state to have an abortion. They can take time off from work. They don't have to worry about losing their jobs. So it's the most burdened citizenry who are sort of left without services, and who I think are in the worst position to rise up. Now, sometimes you can have poor people's movements, right? And we can have amazing things happen. And I think that a brilliant leader might well go into Mississippi and mobilize the women of Mississippi across the board, all races, all economic classes. But I think we can't be too. I don't want to judge those women for not rising up, right? And I also don't want to be unrealistic about expecting that in the rough and tumble of everyday life, the politics of abortion are going to rise to the
But
forefront.
that reinforces the view that it can't just be about abortion services. It has to be about reproductive services. We've brought teenage pregnancy down. I mean, I don't believe we've reduced teenage sex, but we certainly have brought the number of
We have reduced teenage sex.
Teenage sex.
Yeah. But we used AIDS to scare people too. And so it's using Plan B and making sure it's widely distributed, and it's and making sure the whole range of contraceptive services are available as part of this whole movement. We can't just focus narrowly on abortion. It has to be, if we really want to protect families and women, it has to be the whole range of services.
And it has to be men too, and of course it impacts on them.
I mentioned earlier that I had worked with Planned Parenthood. One of the strategies that we adopted in our 6 clinics was we started doing primary care and treating men as well as women patients, because that we thought with broadening the population and broadening the services would take some of the heat off of the micro focus on the abortion issue.
Okay, on that note, I'm sorry, we have to call a halt to this evening's the public version of this evening. I want to thank Secretary Shalala again and our wonderful 3 panelists, and